Good afternoon, Raymond from Legal Management Services. How are you?
I'm well, thank you. How are you doing?
I'm very good, thank you. So just by means of introduction, for anybody who's watching this online discussion, my name is Nicholas Graham. I am an occupational health and safety specialist. I've been in the field for over 25 years. I work between construction, mining, fast-moving consumer goods, etc. And we collectively, between myself and Raymond, have developed numerous COVID plans, COVID risk assessments, etc. And we're meeting this afternoon to discuss the new directive that has come out from the Department of Employment and Labour on the 4th of June 2020, which is now an amendment to the previous directive that was released on the 29th of April 2020. So we want to have a discussion around some of the requirements that you need to consider and some of the new issues that we want to highlight and discuss and chat around how this could influence you as an employer.
Absolutely.
Okay, so Ray, we obviously know that this replaces the previous directive that came out on the 29th of April 2020. Now, the preamble, I don't think there are any specific new requirements that we need to highlight in the preamble. The definitions, there's nothing that flags any specific guidelines other than the fact. Obviously, there have been directives by the Department of Health recently, which has given greater focus to exactly what a vulnerable person or a vulnerable employee in this context is. And these have to be read in conjunction with those Department of Health guidelines as well. Interestingly enough, having looked at some of the figures around the fatalities, is a lot of the fatalities have been in the 50 to 60-year-old age group. So I know that they've drawn the line around who the vulnerable employee is, any person over 60. But I think obviously a lot of the people between 50 and 60 have been going around and thinking, well, I'm not in that category. So I wonder if that's resulted in any at-risk behavior that is maybe, So I think that's something that we need to take cognizance of as well. The application. So one of the points that I want to highlight here, Ray, please feel free to jump in at any time, is point 15. You can allude to any of the previous points if you want. Something for employers to consider is that if you have less than 10 employees, you are not required to do a risk assessment, a COVID risk assessment. Is there anything you want to jump in on clauses 13 and 14?
Well, not 13 and 14, but what is important is that means that everybody with more than 10 employees must conduct a risk assessment. And that's
Absolutely.
really important.
Yeah.
So,
and as we go through the directive, there's going to be a couple of different numbers that we're going to pull together on this, because so if you've got less than 10, you don't have to do a risk assessment. If you've got more than 10, you do. But as we scale up, if you've got more than 500 employees, then there's various different consultations and reviews that has to be done with health and safety committees and with the regulator if you're over 500 employees.
That's right.
Okay, so the plan for reopening the workplace. Now, the requirement to do a risk assessment under the Occupational Health and Safety Act, Section 8, is nothing new. And I think here they have just focused a little bit more to say that a risk assessment needs to be developed, and that needs to be the foundational document for the development of the COVID workplace plan. And we've already done a webinar in which I took you through a detailed risk assessment that employers could consider as a sufficient framework for the development of a COVID plan.
One of the comments I'd like to make on this, and again, you're correct, this is in terms of the Occupational Health and Safety Act, nothing new. But there is an obligation in terms of Section 8 of that Act, if memory serves, to consult with representative unions on its formulation and preparation. So our concern is that employers are going to develop risk assessments, develop plans, present them to employees and say, these are the plans that govern our conduct. And unions may, with some justification, say, hang on a second, you haven't consulted with us, you haven't heard us, and we reject these. So it really is important to consider the obligation on the employer to consult with unions, to consult with employee representatives, and to really engage on the ideas that it has, rather than dealing with this as a tick box approach. There has to be a degree of engagement, Otherwise, we're going to run into difficulties we'll deal with later, where employees resist the measures taken by the employer.
Absolutely. And I think it's also interesting to highlight here as well that there is a consultative and participative arrangement with unions, their representatives, the health and safety committees, and health and safety representatives. But what I want to point out here is that an organization that has, so if you have more than 10 employees, you have to do the risk assessment. But you're only required to have a health and safety rep once you've got more than 20 employees. So there's this kind of small limbo period between 10 and 20 employees where you don't really have anybody to consult with in a formalized structure. So you may not have a health and safety rep or a health and safety committee if you're between that 10 to 20 employees. But obviously you could consult with labor and or somebody, or actually with your workforce, because they're small enough to consult with and around those particular numbers. Okay. Now here, obviously, all of this is now building into the development of the planning and giving a lot of tools and credence to the risk assessment. So return to work and limiting times and schedules, and then also focusing on vulnerable employees as well. Sectoral guidelines, so we're familiar with that. Now, here was an interesting thing that we picked up when we discussed this earlier, is the COVID compliance officer needs to be appointed. Now, it's interesting to note here that the directive requires a member of management to be appointed as the COVID compliance officer. Now, I can understand the motivation behind that is in construction, there's obviously an obligation for the contractor to have a safety officer, depending on various different factors. But in industry, there isn't a legal requirement for a safety officer. So I think the DOEL has considered that factor. And I think they also wanted to make somebody with significant authority responsible for that, for unpacking and making sure that this is implemented.
Well, there's an obligation to ensure compliance, which rests with the safety officer. So I would imagine it would be difficult to do that if the person appointed is not a manager.
Yeah. Okay, some of the administrative measures as well, the risk assessment that we've already spoken about now here. So if it's less than 10, you don't have to have a risk assessment. More than 10, you do, and there's various different consultative and participative requirements. But then also, if you have more than 500 employees, you've still got to consult and participate with your relevant safety representatives, worker representatives, unions, and the safety committee. But then you're also required to provide this information to the DOEL for them to review as well, the policies, etc. Right. Let's take special measures to mitigate COVID-19. Now, vulnerable employees, we had an interesting discussion around this earlier, and there's a common misnomer that under the COVID directives that vulnerable employees can't work. Talk to me about that, right?
That's not accurate.
Absolutely.
Simply means that vulnerable employees, that's people with existing comorbidities or who are 60 years or older, have to be listed. In other words, have to be identified, and special measures identified by the employer to accommodate or to take additional precautions if necessary for those employees to work or to return to work. And the reason for that is obvious. Among the comorbidities listed are immunosuppressed, so people with HIV or other medical conditions. Think of TB, people with hypertension, people with diabetes. That's a huge proportion of our society would be in that category. And it would simply be unsustainable for business not to have those people at work, people over 60. Simply means that because they're in a higher risk category, appropriate measures should be identified by the employer to accommodate that risk. So just as a practical example, perhaps instead of having a social distance of 1.5 meters between desks, maybe 2. Maybe a higher grade of mask, instead of a cloth mask and a surgical mask, or higher. So there are additional factors. Also, the vulnerable employees, and this corresponds with the World Health Organization's list of comorbidities. So it's compliant. When it was compiled, the idea was primarily that this was a pulmonary disease. It affected the breathing, the lungs. Subsequently, there's a lot of data to suggest that it's more a disease of the blood, and the considerations have been adjusted because the high morbidity or the high rate of deaths among older people came from Italy, where there was a very high percentage of the population that was old.
Yeah.
We're now seeing, as you pointed out, and you're right, a high morbidity rate between the ages of 50 and 60. And many people are dying with strokes and embolisms.
Mm.
Not simply because of complications of breathing in the lungs.
Sure.
So it's more nuanced, it's more complicated than that. And that's why people with existing comorbidities and who are older than 60 should perhaps get a medical fitness to work before returning to work.
Sure. So what I'll just do is I'll highlight the specific requirement here. It says that the employer needs to take special measures to mitigate COVID risks for vulnerable employees in accordance with the Department of Health's guidelines to facilitate the safe return to work. So they're not for a second saying that they can't work, to facilitate the safe return to work or working from home. So I would expect the employer to be providing an FFP2 K95 mask to somebody who's a TB sufferer working in the workplace. And again, I would be looking at the arrangements that they're working under, etc. So yeah, I think it's good for us to highlight that as well. Okay, and again, here we go.
And why that's relevant is I've had several instances now of people approaching me and saying, I've been told I can't go back to work because I'm 60. Or I've had employers saying, well, geez, I've got some really critical people who are 60 years of age and they can't come back to work. I've got a problem. It's simply not the case. Neither is it the case with comorbidities, as we discussed.
Excellent. So here's that point, 20.6, you must appoint a manager as the COVID-19 compliance officer for the organization. And any of those points after that highlight what the responsibilities of the COVID compliance officer are to ensure the risk assessment, to ensure that the COVID plan is given effect to within the organization, that people are trained, informed, etc. So that's really everything that they're going on with regards to. And I also celebrate the fact that a manager needs to be appointed. I'm sure they may cascade some of those responsibilities down to the safety officers, etc., within the workplace. Okay, so here, a lot of the common stuff that we've seen already within workplaces, social distancing and the various different controls that need to be put in place. Now, Ray, you and I are going to be doing a webinar on this later this week. So I don't want to draw too much attention to this now, but it's clear on what the employer has to do if somebody is diagnosed with COVID in the workplace. And I think maybe if you and I are going to focus on anything, I think I'd like to highlight a concern here is that it says here under 20.11.2 is that what? Let's have a look here. If a worker is diagnosed with COVID-19, an employer must. But causation here is impossible to prove. It's going to be very, very difficult to prove where the person, was it in the public transport on the way here? And my concern here is that this opens the door for employees to say, I've contracted this at work, therefore it's a COID claim, and it's going to then draw on your workman's compensation and drive your insurance claims through the roof. And again, the employer, as we both know, is not allowed to repudiate the employee's claim. He then has to submit supporting information through to the compensation commissioner for them to be able to make the call.
Correct. Exactly right.
And I'm very concerned about that it's going to, I have no problem if a guy is diagnosed, if they have contracted it at work, and that is causation, and we've investigated, we know that that's where it's come from, particularly if there's been an outbreak in that workplace, for the COID insurance to be able to pay for the best possible treatment. But I'm concerned that the employer is being hung out to dry here, possibly, and that their insurance is going to end up covering the bill for exposure that could have happened in any work, in any environment. So social distancing, I think this is quite clear. I think we've had social distancing narrative for quite some time. Screening of symptoms, you and I have already spoken about this and what needs to be done. I think if you've been venturing out to any workplaces now, you will have had some form of screening that's taken place. COVID-related symptoms. Now, maybe if we could stop here for a second. Now, again, I think there is a misnomer that you can only return to work once you have been classified as COVID negative. What's your opinion on that as well, right?
That's not the case. So 28.1 says the worker has completed the mandatory 14 days of self-isolation. So in terms of the NICD guidelines, that's 14 days from the date of becoming symptomatic, if it's a mild experience of the disease, or 14 days from the last day on which they required therapeutic oxygen, if it was a severe situation. But you'll see at 28.5 that there are additional measures. The worker wears a surgical mask for 21 days from the date of diagnosis. So that's different to the NICD guidelines, which deals with it symptomatically. This deals with from the date of diagnosis.
Sure.
And it does mean that the employer has to bear those timeframes in mind in addition to the 14-day timeframe in providing appropriate PPE to its employees.
Absolutely. So then when a worker returns to work, a cloth mask is not going to be considered sufficient. They should be wearing a surgical mask. So if they return after 14 days, they've got another 7 days in which they've got to wear surgical masks within the workplace. Okay, then also I think there's a lot more clarity around high risk or low risk transmission between workers depending on the work environment and the setup and the proximity that people have to work with each other as well. That's obviously been emphasized within the directive. And again, I'd like to emphasize the fact that the employer has to apply their mind to what PPE needs to be provided to employees. As I said, I'm a proponent of cloth masks within a public environment, but one of the things that the directive is quite clear on, that where the risk applies, accredited PPE needs to be provided by the employer to the employees. So that's, and a cloth mask is not accredited PPE unless somebody's got some form of test certificate that has been done by an accredited organization. Cloth masks, and again, we're familiar with all of that. Measures in respect to workplaces. So here, I've had the pleasure of dealing with a lot of retail solutions and shops recently. Here they, again, draw some fine-tuning focus around retail solutions, all those workplaces which are open to the public. So, I mean, here we could also look at schools. So this is, one is a school is a workplace for the teachers, but it's also a place that is open to members of the public. And they've got some specific requirements that they need to focus on around that.
Yeah.
And I think it's going to be quite interesting, particularly when it comes to PPE for students as well, because, you know, for PPE to be effective, it has to be wearable, ergonomically correct, and also be effective. And I have a concern with young children's ability to be able to keep any of that stuff on. So face shields may be the best form of, the best solution. We've spoken at length about ventilation and filters and increased natural ventilation and mechanical ventilation as well. And here's where the directive speaks about that specialized personal protective equipment where the risk dictates it. One of here, Raymond, is the one area that I think you and I wanted to focus on the most, and I'll let you lead the charge here.
Yes, so this is an interesting development at 48. It says an employee may refuse to perform any work if circumstances arise which with reasonable justification, that's the key, appear to that employee or to a health and safety representative pose an imminent and serious risk of their exposure to COVID-19. So it's not just that an employee says, I'm scared I'm going to get COVID-19, therefore I'm not coming to work. There has to be reasonable justification for it. and the risk must be imminent and serious. So what is interesting to note, however, is that it's not the health and safety representative and, it's the health and safety representative or. The health and safety representative could technically say, I'm happy that there's no risk, continue. And the employee may still, nonetheless, hold a reasonable and justifiable view that there's an imminent and serious risk. In my view, if an employer has conducted the appropriate risk assessment and has a plan and is complying with that plan, it's difficult to imagine circumstances where such a reasonable justification would arise, especially to jump over the hurdle of it being imminent and serious. So I think to avoid 48, to avoid Section 48 being an issue, a proper risk assessment should be conducted in consultation with the appropriate employee representatives, and a proper workplace plan should be developed and implemented. And here's the key: employees should be appropriately educated on what measures are in place and what the reality of the risk is, so that we don't run into this difficulty. There could be circumstances where an employee or union or other representative body may be overly cautious for justifiable reasons, or perhaps for less justifiable reasons, and may seek to use this as a measure to bring kind of pressure on an employer to accede to other demands. We don't know.
Yeah.
But the legislature has anticipated that, because it's gone on to say, if you look down, I think it's around 50-51, just scroll down. Just go further to, it says that no person may advantage or promise to advantage any person for not exercising his or her right.
Yeah.
So what that does is it removes the refusal to work, from the realm of any matter of mutual interest.
Mm.
It's really important. On the face of it, it looks like it's protecting the employee, but it also protects the employer, in my view. What it does also is it triggers at 49 what has to be done. If the concern has been raised, well, what happens? Just scroll up to 49, please.
Will do.
It says an employee who refuses to work must, as soon as reasonably practicable, notify the employer, either personally or through a health and safety rep, and provide the reason. And the employer must then, in consultation with the compliance officer, endeavor to resolve any issue. So the employee can't sit at home and say, I'm not coming to work because I'm scared that I'm going to get infected, and leave it at that. There's a process. And once the employee is obliged to follow the correct steps and to provide sufficient detail for an assessment of the risk, the employer is simultaneously obliged to take appropriate measures immediately to address those concerns. And if it's not resolved, the employee then has the right to refer a dispute to the CCMA or to the appropriate bargaining council. You'll see further down.
Yeah.
You'll also see that an employee may not be subject to disciplinary action for a reasonable refusal to work. And that's really a reinforcement of the common law. The common law says that in order for a charge of insubordination to succeed, the instruction, in this instance to work, must be reasonable and justifiable. It couldn't be reasonable and justifiable to insist that somebody works, where their continued work would be a serious and imminent risk of exposure to the disease. All of that lines up with the common law, it lines up with the Occupational Health and Safety Act and its regulations, and it lines up with the existing legal position. What it does is it sets out what the procedure is and what the expectations of the relative parties are, as far as complying with their obligations is concerned.
Yeah, so I think both of us share a common concern here. So I'll start off with my background to this. The chief inspector has for some time said that this caveat is going to be built into the Occupational Health and Safety Act. So not just around COVID, this is something that is coming into the Act in future, where an employee has the right to refuse to do unsafe work. And this
Yeah.
has been in the Mines Health and Safety Act for some time. I would have preferred if the terminology had been where an employee in consultation with the health and safety rep. I think that would have been terminology that was a little bit safer for all parties concerned. And I think from an employer's perspective, there's a long time, and if this did occur, I mean, it's 100% valid if the employer has done absolutely nothing to control COVID within the workplace, 100% valid. But if this was going to be used as a mechanism by an employee, and we both know that it's highly unlikely that this would happen in isolation, is a group of employees may then refuse to do unsafe work. There is a time frame here that could occur between guys refusing to do unsafe work, going for arbitration, etc., and an outcome, in which time, as we know from the requirements below, there is no financial impediment to the employee whatsoever. If so, it's only to the employer.
Well,
so yeah, carry on.
Yeah, that's a very interesting question. So if the employee says, I refuse to work because I believe that it's unsafe, and the employer says, well, we've investigated in consultation with the safety group. We believe that it's safe. We've sought external advice. The external advice says it's safe. We believe your refusal to work is unreasonable. If you insist on it, by all means, go to the CCMA or go to the bargaining council and let's fight it out. And we're prepared to defend ourselves. But in the meantime, the principle of no work, no pay applies.
Aha. So that's the interesting.
Now that's untested.
Yeah,
it's untested. That's my view.
Yeah, but I mean, you're a labor lawyer, so you're probably one of the better qualified people to give an opinion on that, which I think anybody listening to this would find very helpful.
Yeah, and again, that's subject to the employer having jumped through all the hoops, having consulted, having engaged, having assessed, having implemented, having done everything it's supposed to do. If it forms the view that the position adopted by the employee is unjustifiable, then they're in the same position that they would be if somebody says, well, I'm sick, I'm not coming to work. And the employer conducts an investigation, comes to the view that they're malingering. The employer is perfectly justified in not paying them until it can be proven otherwise. So I have no difficulty whatsoever in an employer saying, here are the steps I've taken. I'm ready to defend myself. I've done everything reasonably required of me. The approach adopted by the employee is unreasonable, but the commissioner may come to a different view. Until then, I'm not paying it.
Yeah.
Because no work, no pay.
Yeah. So this is a risk to the employees who could possibly adopt that strategy where they may not have worked for a month and the employer said, well, I'm not going to pay you. And then based on the outcome of the commissioner, they may find themselves without a month's worth of pay if the employer can demonstrate that they acted reasonably.
Okay. Just bear in mind that clause 54 says, no employee may be dismissed, disciplined, prejudiced, or harassed for refusing to perform any work as contemplated in clause 48.
Yep.
That means that they may be prejudiced if the requirements of clause 48 aren't satisfied.
100%. Great point, Raymond. Very, very good point.
So I don't think that, and I'm fairly confident that I'm going to have this argument in court or in the bargaining council or in the CTMA.
Sure.
I'm fairly confident that an employee representative is going to take the line. Well, as soon as I've voiced my view, I'm immune from any prejudice, and that means you have to pay me even if I'm wrong. And the question is going to be, well, it's not whether you're wrong, because people get it wrong all the time. Reasonable people may reasonably differ. Whether there is, and you'd have to go to the clause,
sure,
a reasonable apprehension of imminent risk, imminent and serious risk. And absent imminent and serious risk, I don't think that they can say, well, I'm staying away and I must still be paid.
Yeah. So I think those are the key terms there. And the regulator and whoever has drafted this has taken that into consideration by using that particular term. So I don't think employers should feel as though they are placed in unnecessary risk. Again, it's a consultative and participative process. If you've done your risk assessment, you've got a comprehensive COVID plan, sanitizing, social distancing, engineering, administrative controls, it's being monitored, people are being, and as you so rightfully said right at the beginning, the more we train and educate our employees, the better we're able to manage any perceptions, because there's a lot of hysteria around COVID as well. And people seem to think that it's a heat-seeking missile, that it bends around corners and under face shields and all kinds of various different things. And we need to be able to deal with those perceptions in an informative, consultative and participative mechanism.
Exactly right.
So I think that's been very helpful, and I think employers need to apply their mind and maybe build that into their processes and agree upfront on a mechanism for discussion with the health and safety reps and or health and safety committees, so that it doesn't come down to some form of arbitration, so you can head that off.
Really,
yep.
If the employer does what they're obliged to do, they're safe.
Yeah. Now, interestingly enough, I know that the DOEL inspectors are going around as well. I took my boat this morning to have the COR done on the trailer. And I drove up to the testing station and the guy said, no, sorry, we've been closed down because the inspectorate came around here the other day. They obviously didn't find us to be compliant, and they've shut down NATIS and all of the stations from performing any inspections. And now if you walk in there, the signage and everything up all over the place. So I think organizations need to prepare themselves for sweeping inspections by the inspectorate and a lot of closures if the employer cannot demonstrate that they're acting reasonably. And again, I mean, both of us work in this arena. I don't think it's expensive for an organization to invest in a risk assessment that's been developed by a competent individual or individuals, and a COVID plan, and then some training. I mean, that's not going to cost an organization a lot of money versus the cost of business closure, reputational damage, the deterioration of the level of trust with employees, etc. So those two there's a minimum offset for a maximum value in my mind.
And if I may add to that, everybody and their dog is now selling workplace plans off the shelf.
Oh, yes.
You can buy them between 550 Rand up to, I've seen about 1,200 Rand. The problem is, whilst that's not a bad foundation, it's not the workplace plan contemplated by the legislation at all.
Absolutely. Yeah.
Because the workplace plan has to be developed with reference to your workplace and your workforce. And if you think you can buy a workplace plan off the shelf and stick it in a drawer, which is where most plans go, until there's a drama, when the drama hits, you're going to be caught unprepared. It's got to be done in consultation with your employees. It's got to be done with reference to your particular workplace. And it's got to be done having regard to the arrangements that are in place to limit risk to the employees and to members of the public, and to enforce social distancing in your circumstances, which is going to be different for a corner cafe to mine. So it really depends on the business itself. Yeah,
no, absolutely. And I think the COVID plans that I've seen to date by organizations that haven't utilized professional services, and it's a short 2 or 3 page what to do, how to clean surfaces, but I have not seen a comprehensive risk assessment that would pass muster, or that I would be confident to take into a court of law to date. So that seems to be the big gray area. And I think it obviously just goes into the references, etc. So for us, I think the key points to mention there for any employers to take cognizance of, particularly this one, refusal to work. If the employer hasn't prepared the risk assessment COVID plan, is taking reasonable measures.
Absolutely right.
Excellent, Raymond. Is there anything you'd like to say in parting?
No, I think we've covered it. Really, if I can just underscore what we've said before, don't panic. Don't panic. All of this is built on the foundations of the existing legislative framework, Occupational Health and Safety Act. Workplace plans are nothing new. We're simply focusing on the implications of the existing system on the current pandemic. And if you do things thoroughly and clearly, and with the best interests of your employees at heart, you're not in danger. Everything will be fine.
Absolutely, Raymond. Thank you again. It's always a pleasure spending time with you. Thanks for your professional opinion. And I'll catch up with you later on this week for another webinar where we're going to be focusing on what the employer's responsibility is when somebody is identified to be COVID positive in the workplace.
Fantastic.
Ray,
I look forward to it.
thanks again for your time.
Take care, man.
Cheers, Zane.